The writ petition is dismissed. Thank you.
For mentioning Mr. Ashish Mishra. Supplemental list for admission, item number 2.
My lord, in this case, on 25/2021, my shop at Arakata IFL of shop was sealed for seizure of 21.780 BL of non-duty paid duplicate foreign liquor, along with the seizure of 656.61 BL of IFL and 462.750.
I'm not able to understand.
beer. My lord.
You're awaiting outcome of writ appeal before the excise commissioner.
That is what also I was. That
How can a writ appeal be filed before
that
excise
is,
commissioner?
perhaps it is wrongly mentioned. It is appeal.
2 orders, the same thing is mentioned. What is the appeal pending before the excise
My
commissioner?
lord, excise commissioner, excise appeal, the under section 4 of the Excise Act. It was appealed before the excise commissioner, and he has also heard the matter on 7th December 22, but he has not yet communicated any order to the in respect
Then
of.
only if that order goes against him, then only cause of action will arise to.
It is stated that the excise commissioner has heard the appeal on 7th December and orders are awaited. Full stop. If the orders have not been pronounced, direction is issued that it should be pronounced positively on or before 15th March 2023. If such order is adverse to the petitioner, it will be open to the petitioner to file, to seek appropriate remedies in accordance with law. The petition is disposed of. A copy of this order be communicated forthwith by the registry to the excise commission.
Obliged.
Obliged.
Yeah, let him.
Supplemental list, fresh admission, item number 1.
May pardon, my lord, I am on VC, my lord.
Yes.
I have filed I filed the affidavit with my regret and my apology before your lordship for my non-appearance on 28 August 2022, my lord.
Where have we filed that affidavit?
Affidavit filed, my lord, at Para 4, my lord. I have disclosed my regret, my unconditional apology before your lordship, my lord, for non-appearance.
No, not this is not apology for hardship faced by the court, sir. This is not about my hardship faced with the court. Sorry, this is not the apology I'm asking for.
My lord, apology for my non-appearance, my lord. I am begging apology for my non-appearance, my lord.
So you know what you have to do. I don't have to tell you. I'm going to place this in August, sir. You explain to whichever is the judge. All right. It's better I don't hear these kind of matters. 11th August.
Item number 2.
Not space 126 is my arbitration clause. Space 411 is my arbitration notice.
Yes.
Notice.
Notice returnable. 17th March.
Item number 3.
Hey, please, your lordship, my lord, I'm for the respondent now.
Yes,
Lordship would kindly peruse flag 10, my lord, which is the letter of the learned arbitrator.
personal reasons. All right. The learned arbitrator has informed that due to personal reasons, he cannot continue as such. Whom should we?
Lord, I was suggesting, my lord, subject to your lordship's consent and my learned senior's consent, my lord, Honorable Justice Biswajit Mahanti, my lord.
My lord, can it be some senior advocate, my lord? I don't have any objection for.
My lord, it was being dealt with by a learned honorable judge, my lord, and this is a public sector. Otherwise, I wouldn't. That is the.
All right. The court accordingly appoints Justice Vishwajit Manthi, former judge of this court, as arbitrator to continue the proceedings from where it was.
Yes.
The arbitration will take place in the aegis of the arbitration center.
Deeply obliged. Deeply
Right.
obliged.
Lord's flag number 10 is my IA. The next matter.
Item 4.
This
Flag number 10 is my IA, my lords. I have.
this matter, my lords, it was a three-member tribunal.
Mm,
So I had sought for time and my lords had given me time for appointing a nominee.
mm.
Unfortunately, that hasn't not happened. If my
Hmm.
lords calls it next week, sometimes my lords, it's.
So we'll simply adjourn it.
My lords, my search. My lords, once I have approached this honorable court and 30 days has passed in the interregnum, no other appointment can be done. My lords was even kind to grant them an opportunity to appoint. They did not appoint. My lords, I am not praying something that someone I suggest may appoint. Any retired judge from this.
We'll just keep this for
Next-
2 weeks. Next week is 17.
My lords.
We'll keep it on 24th.
Great.
I'll just adjourn this to 24th. Let's see what happens.
They will appoint my lords. The problem is there will be 3-member tribunal. I have to deal with financially very on me.
You should agree to that. How suddenly you can't become financially weak? You would agree to that.
My lords, my whole purpose coming before this court was to get a single member.
But that's only order where we asked him to.
If he can agree, I can, any high court judge, my lords may ask.
24th. We'll do it on 24th. All right. Just list on 24th. All right.
Item number 5.
Lordship, my client is honorable, you cannot remove that defect. Lordship, one date may kindly allowed, Lordship. You have to get the certified copy of that original order of the lower court. That's the reason, Lordship, pray one adjournment.
All right. At the request of Mr. of the learned counsel, the petitioner, list on 24th of February. All right.
Item number 6.
My lords was pleased to issue notice.
Mm.
My lords,
Delivery confirmed.
no, yes, noting is that it was delivered to opposite party number 2, the main contestant party.
All right.
My lord, I'm appearing on VC, my lord. I'm
Oh.
filing Wakalatnama today.
I
I've
see.
got instruction to, I'm filing Wakalatnama, my lord, for
All right.
1 and 2, my lord.
All right.
My lord, I only pray, my lord, because, my lord, this relates to a work order given in 2013.
Hmm.
So, my lord, may kindly give me some more time, my lord.
All right.
Slightly more than usual to file my
All
counter,
right.
my lord.
All right. Mr. Manthi, enters appearance for the opposite parties. First of he prays and is granted 8 weeks time to file a reply. List on 24th March. Not sorry.
Grateful.
No. 1 minute.
21st
21st
April.
21st April.
Grateful.
Right. Rejoinder for the next day. Right. All right.
Deeply obliged.
Item number 7.
May I please, Your Lordship. Item number 7, I am appearing for opposite party.
Yes.
Today I am filing counter.
Yes.
Just now saw the copy,
What are you saying in your counter? Agreeing, not agreeing?
not agreed, my lord.
Why? Why are you not agreeing?
My lord. The work divided 4 part, my lord.
What? Sorry?
The work divided, my lord, 4 part, my lord. In the contract divided 4 part, my lord. The first and second and third part. Several discussions were made with petitioner and opposite party, but the 4 part they did not discuss and they did not.
What is your claim? What is the value of your claim, sir?
Lordship, it is 66,66,000.
Are you prepared to pay some part of it? No.
No, man.
Might as well appoint an arbitrator, sir. It's on merits only. Your objection is only on merits.
Yes, ma'am.
The counter affidavit of the Union of India has been perused. Give us a copy. The objection is essentially on merits. In other words, the existence of the arbitration clause and the existence of a dispute is not denied. That view of the matter, leaving the respective contentions of the parties open to be, both in fact and in law, open to be urged before the learned arbitrator, this court appoints. This appoints any senior advocate should be all right.
Yes, sir.
Mr. Vivekananda Mohanty. Mr. Vivekananda Mohanty, learned senior counsel, as sole arbitrator.
Item number 8.
Item 8, your lordship, I'm on virtual mode, your lordship. I'm a last occasion I have sought for time, your lordship, on 15/12. I'm awaiting instruction, my lord, only last chance. 64 city, both are connected, my lord, 8 and 9.
All right. As a last opportunity,
My lord.
8 weeks time is granted to file reply rejoinder for the next date. List on 21st April,
My lord, deeply obliged.
8 and 9.
8 and 9, your lordship.
Item number 10.
Item number 10, my lord, voting has been
Delivery confirmed.
confirmed, my lord.
Your lordship, I am appearing in the.
Arbitration,
Okay. And
Satya
then
Kashyap.
same.
This is Kashyap. Yeah, lordship.
Counsel appearing for the opposite party seeks and is granted 8 weeks time to file reply. Rejoinder for the next date. This will have it on 5th May.
My lord.
Item number 11.
My lords, item 11 with respect to OP2, the notice is
Yes,
sufficient, my
no.
lords. And with respect to OP1 is the headquarter of the respondent, my lords, and OP2 is the branch office.
Nobody's appearing. All right. The notice sent to OP number 2 has been returned with an endorsement of refusal. Stop accordingly, the opposite party is taken to be served. What's your claim? What's the amount?
Well, it's around 66,70,000.
The court appoints Mr. Gautam Mukherjee, senior counsel, as sole arbitrator to adjudicate the dispute between the parties, including the claims and counterclaims.
Great.
The arbitration will take place in the aegis of the arbitration center. All right.
Item number 12.
Notice has not issued.
All right. Mr. Acharya appearing for the opposite party seeks and is granted 8 weeks to file a reply, rejoinder for the next date, 5th May. All right.
Specialist fresh admission item number 1.
None of is dismissed.
Specialist fresh admission item number 2.
May I please, Lordship? Lordship. Opposite parties petition on under
138.
No, Lordship, 205. Personal appearance of that.
That all that is over. Now we'll fix a date you appear. Because there's a stay here.
No, Lordship, that is
Then
not.
it's over. You say it will always be open to the petitioner. There's been no interim order during the pendency of this petition. It will always be open to apply to the petitioner to apply afresh on any particular date when exemption is sought from appearance in the trial court. The petition is disposed of. Right.
Item number 3.
May I please, your lordship? In the meantime, trial is over, it becomes
Infraction was dismissed as infraction. All right.
Item number 4.
None appears dismissed.
Item 5.
None appears dismissed.
Specialist item 6.
Lordship, on behalf of Mr. Pal, permitted to withdraw with the
All right.
liberty to raise all the points
Yeah,
at the
all right.
the time
Permitting
of
the
framing of
petitioner to
charge.
raise all fees. Right.
Obliged.
Item number 7.
None appears dismissed.
Item number 8.
Same order.
Specialist item number 9.
In this case, that is better be called on after 4 weeks because in a similar prayer, WPCRL 1047 of 2013 was passed. And in that case, while disposing, the Honorable Court has directed to move the trial court on the basis of the judgment reported in that is Shakiri Vastu versus State of Uttar Pradesh.
All right.
And I've taken instruction yesterday that the petition is filed in pursuance to the order dated 5/1/2018. And the matter is pending, is not yet been, no order has yet been passed. So in that case, if that order has been passed and some positive order is passed, it becomes automatically infructuous.
All
But
right.
if it is not
At
there,
the-
then this matter can be taken up.
All right. At the request of Mr. Mishra, and counsel for the petitioner, let's move to the roster bench on 12th April.
Man, Lord, may I pray 172-73, if your lordship will not take it otherwise. There are 4 matters, let it come along with other 3 matters which I am giving the number. Because by petitioner is same. One matter was listed for your lordship on 3/2/23, where a report was called for. It is a job, the petitioner is a journalist and the police has unnecessarily implicated him in the case. And there are 5 cases, 5 to 6 cases.
So when is that coming up? The other one?
The other one has not yet started for a long time.
No. The 3rd February, when did we adjourn that to?
Yes, 3rd February, it is your lordship directed to call for the report is not yet received. And something, I mean, I have not taken down the note, my lord.
What was that number you tell us? 3rd
Number
February
is criminal mystery 34 of 2018.
34 of 2019.
18, man. And there are 3 other matter, 302, 3361 of 2013, and 3362.
That's coming up on 3rd April. So this is 71-72.
This is 72-73, my lord.
72-73. You say list along with
CRLMC 302 of 18, 3361 of 2013, and 3362 of 2013. These are
on 3rd April. All right.
Obliged.
Milord, may I pray with your lordship's permission? Item number 5. Item number 5, Milord, my appearance for the opposite party state vigilance.
All right. 5 and 6 also.
No, only 5.
Achha, only 5. All right.
Specialist item 10.
I am challenging the cognizance order taken by the learned SDGM lordship.
What's the offense, sir?
Offense is under section lordship 341, 323, 294 and 506 along with 8 and S of the SCST Act lordship. As this is the special act.
SCST, sir.
Lordship. Last occasion your lordship has called for the report.
I know. I see. A report has been received from the SDGM Rourkela stating it is not known under what circumstances the predecessor took cognizance under the of the offense under the SCST POA Act without transferring the case to the special court established for the said offense. Paragraph. In that view of the matter, the impugned order dated 19 May 2017 passed by the SDGM is set aside. The matter is now remanded to the learned district judge.
Special court.
No, straight away we send the special court from here or let the district judge place it.
The special court will take
All right.
cognizance.
Matter is remanded to the special court. But in Rarakol, there may be no special court.
The Rarakol.
No, there will be. It's better to place of the district judge. He'll place it. District Judge Sundar. This is Sambalpur, right? Rarakol is Sambalpur. District Judge Sambalpur, who will in turn place it before the special court for trying SCST POA Act offences. a copy of this order be sent to the learned district judge as well as the concerned court forthwith. Right.
Item number 11.
Item 11, on behalf of M. Das, no instruction, my lord.
No instructions dismissed.
Item number 12.
None appears dismissed.
Item number 13.
My lord, the petitioner is the husband. The marital dispute between the husband and wife has been settled, and the permanent alimony has been paid, and the criminal proceeding which was pending.
Where is all that? Where is the order for that?
My lord, that is annexure 3. Before the JMFC Kotam date, the matter was settled, and
All right. It appears that the matrimonial disputes between the parties have all been settled as per the Annexure 3. But then no notice went in this, sir.
yes, my lord.
This is even before notice. At least file an affidavit of that woman.
Yes.
Notice to, he accepts notice for 1, notice to respond, but 2 be served thusly. Placed before the roster bench on 24th April.
Item number 14.
No instruction. No instructions dismissed.
Item 15.
No instruction.
No instructions dismissed.
Item number 16.
None appears dismissed.
Item number 17.
Same order.
Item number 18.
Same order.
Item 19.
Same order.
Specialist item 20.
Same order.
Item number 21.
Same order.
Item number 22.
Same order.
Item number 23.
May I please, Your Lordship? Your Lordships will raise all contentions in the court below the time.
Permitting the petitioner to reason.
Okay.
Item number 24.
May I please, ma'am?
My lord, item number 24 and 25, similar. My lord, the advocate Antarjam Swai is dead. मैं प्लेट ऑनर जी 7 दिन समय दियंतु फाइल टा खोजी करे प्लीज 7 days time.
For what? Not necessary, sir. What is the order here? We just permit the party to raise all pleas at the appropriate stage. What is this?
24 and 25.
Permitting the petitioner to raise all pleas at the appropriate stage in the trial court. Petitions are disposed of.
Published.
Item number 26.
None appears dismissed.
Item number 27.
Copy the order. None appears dismissed.
Item number 28.
None appears dismissed.
Item number 29.
Same order.
Item number 30.
Same order.
Item number 30.
Yeah, 30 none dismissed for non-resolution.
Item 31.
There should be no instruction.
No instructions.
Item 32.
None appears dismissed.
Item number 33.
No instruction.
No instructions dismissed.
Item number 34.
None appears dismissed.
Item number 35.
None appears dismissed.
Item number 36.
And also no interest. No instructions dismissed.
Item number 37,
None appears dismissed.
item number 38,
None appears dismissed.
item 39,
Same order.
item number 40.
May please your lordship, I am in the virtual mode, my lords.
Yes, sir. Yes.
Your my lords, after the charge sheet was filed, an application was filed. The facts are like this. The OSRTC boss met with an accident with a truck. An FIR was lodged by an outsider. The cleaner of both the cleaner and driver were injured. But as the cleaner was died at the instantly, and the driver fled away and was admitted in the hospital, he was not implicated as an accused in the case. The owner of the vehicle filed a petition. He only came to know about this after charge sheet was filed. He filed a petition under section 178(3) to make further inquiry and implicate driver as a party. That was rejected. I have approached this honorable court. The rejection order is at the last page. And I have also given a copy of a judgment or today.
No, but there was no stay. By now, trial should be over.
No, I have checked up today. Nothing has been done. It has been transferred to a magistrate court. I have checked up in the morning. If your lordship trusts me.
Okay. All right. Mr. Das, learned senior counsel, informs the court that as per the information available to the petitioner, the matter is still pending in the trial court. Paragraph. It appears notice is yet to issue in the present petition. Will stop Mr. Manti appearing for the state, seeks time for instructions. List before the roster bench on 4th April.
Item 41,
None appears dismissed.
item number 42,
None appears dismissed.
item number 43,
None appears dismissed.
item number 44,
Lordship, I'm through virtual mode, Lordship.
Yeah, memo taken on record. Infructuous disposal.
item 45,
None appears dismissed.
item number 46,
In this case, my lord, the FIR lodged against the petitioners due to acquire of the forest land, my lord. So, my prayer for quashing of FIR.
Sir, now stay was granted. This matter has been there for 5 years. Now it must be over, sir.
My lord.
Actually, all these matters also, I think the state government is withdrawing some of the prosecutions. Permitting the petitioner to raise all pleas at the appropriate stage. The petition is dismissed.
item number 47,
No instructions dismissed.
item number 48,
None appears dismissed.
item number 49,
My pleasures. Here, my lord, petition number 1 and OP number 3 played away and out of love they got married and.
Why don't you file her affidavit?
My lord, extra copy was sought to take instruction, marriage photographs and everything.
I know, but you'll have to file her affidavit. The affidavit.
And 2 extra copy was also sought to take instruction on.
When?
By order dated 14/5/2018, my lord, regarding that effect, my lord.
14/5/2018.
Yes, my lord.
No, there's no such hearing. This is Neelu Raut, right?
Yes, my lord.
No, there's no such order. Just show him the file. Just show him the paper. Is it the same matter?
Matter, but I today got my lord, download copies from the my lord.
Just see the file.
Yes, my lord, but today I got the
No, maybe
download.
some other matter. No, my lord, this file 549 of 2000. We'll check up, but in the file, there is no such order, sir.
Yes.
Counsel to the petitioner claims that the petitioner number 1 has married opposite party number 2. 3, my lord. 3, there's no opposite party 3 here. Oh, 3, yeah, opposite party number 3. Full stop. An affidavit of opposite party 3 be placed on record. List before the roster bench on 5th April.
Item number 50.
No instructions. All right. Memo taken on record.
Item 51.
None appears dismissed.
Item 52.
None appears dismissed.
Item number 53.
Please, Your Lordship. My lord, this case is at the stage of framing up charge. I want to withdraw this application to raise all my
All right. Permitting the
at the
petitioner.
stage of framing up charge, my lord.
Whenever, sir, at the appropriate stage. All right.
Item number 54.
In item number 54, my lord, the petitioner is a principal of the JP College, my lord. Here, factual matters of the present case is that.
SC Act, I'm sure.
Yes, my lord. My lord, if factual matters of the case is that the petitioner on 15/8/2013 joined the college as a principal in charge of Panchayat Samiti College, my lord. Thereafter, upon verification of educational year record, say from 2013 to 14, it is borne out that there is no such order has been placed.
All this will have been matters of trial, sir.
Yes.
Permitting the petitioner to raise all pleas at the appropriate stage.
Lord, the thing is that the opposite party number 1 filed an FIR. But that final report has been given in the FIR that FIR is a false case. Immediately thereafter, he filed a 160
private
case.
complaint. Yeah, yeah. It's all normal practice, sir. Well, nothing unusual. All right.
Specialist item 55.
None appears dismissed.
Item 56.
None appears dismissed.
Item number 57.
My lord, I am in the virtual court, my lord. My lord, virtual, my lord.
Yes, tell me.
My lord, the criminal division, my lord, conviction 7 years, so that I will dismiss for non-persecution, my lord. Your lordship will give him liberty to revive the petition, my lord. The petitioner arrested in the meantime, my lord.
All right. For the reason stated, all right. For the reason stated, the order dated 9 September is recalled, and criminal division 637 of 2003 is restored to file. What is the matter there, sir? Main matter.
7 years of conviction, my lord. 307 of IPs, my lord. Conviction
All
7
right.
years. My lord.
All right. List before the roster bench. 18th April. All right.
Oblige.
Item 58.
My lord, here I am seeking restoration of my application. I had missed the list, so I am seeking a application for restoration.
For the reason stated therein. No, the statement made before us is no instructions, not default. This is criminal NC 6151, right?
Yes, my lord. But here, my lord, it was mistakenly done by my associate. So, but there is subsisting interest because your lordship will see
Okay,
that.
Mr. Bose now informs the court that an erroneous submission had been made before this court that there were no instructions. Accordingly, the order dated 5/8/2022 is recalled, and criminal MC 6151 of 2014 is restored to file. In that main matter, you say list before the roster bench, 10th April.
The interim order may be extended.
Interim order to continue.
Item number 59.
None appears dismissed.
Item number 60.
Same order.
Item 61.
Infractuous dismissed.
Both. Item number 62.
62, my lord, permitted to withdraw with liberty to move by filing distribution all the points raised at the time of charge. That
Correct.
observation. Person is the father-in-law.
All
The colleague of the deceased has told that she is leaving because of her father-in-law. No,
All right.
all the points at the time of charge.
All right.
Obliged.
Item number 63.
None appears dismissed.
Item number 64.
None opposed, dismissed.
Item number 65.
My lord, well, here my application, under application 311 was rejected, my lord. Challenging that order, I up to additional court. That is that annexed 2, page 80, that the order, my lord. I filed application under section 311 to recall the Video 12, my lord. And then the annexed 1, that is the specific 4 questions are put for jurisdiction case, my lord. The offenses are in.
Which is the order you're challenging?
That is on page 8, my lord, annexed 2, my lord.
Annexure 2.
Yes.
Annexure 2 is FIR. Which is this item you are appearing? MC 94 of 2018.
No, my lord, 8085 by 2018. That is 8085 by 2018.
Aha. So 8/1/2014 itself she has been examined, sir. Why did you wait for 3 years?
Okay, the 4 questions are left, my lord.
No, after 3 years.
No. Because 311 is the, my lord.
No, it's not for the asking, sir.
My lord has
the impugned order.
Our, my lord.
No.
There are only 4 questions, my lord. It is that the offense is 376 and other offense, my lord. The victim is one.
This is all harassment, sir. The victim is PW12.
My lord.
Better leave her be. The challenge the present petition is to an order dated 16/12/2017 passed by the Additional Sessions Judge bracket Women's Court bracket Nayagarh, dismissing the application filed by the petitioner accused for recall of the victim girl PW12 for further cross-examination. Stop. It is seen that ST case number 30 of 64 of 30/64 of 2013/2012, which arises from GR case number 33 of 2012 and Ranpur PS number case number 33 of 2012 under
Para 3, my lord. Para 3, my lord, offense is there, my lord.
under sections 363, 366, 376, 109/34 has been rejected. On the ground that the questions intended to be put to the witness were not material and not essential for a just decision of the case. Paragraph. It is seen that the application itself was filed more than nearly 4 years after the victim girl was examined and cross-examined by the defense on 8 January 2014. First off, there was no reason for the defense to have waited for more than 3 years to file such an application. Further, given the offenses with which the petitioner has been charged, the court views the attempt at recalling PW12 for further cross-examination as a delaying tactic. Full stop. The trial court was justified in declining the petitioner's prayer. There is no merit in the present petition. It's dismissed as such. Interim order is vacated. Memo 64 memos taken.
Item 66.
May I please, Lord?
My lord, in this case, this is the case for 1cc 77 of 2016. Arises out of 1cc 77 of 2016, my lord, under Annex 5. And the petitioner challenges to set aside the order dated
138 NI Act.
My
You're
lord.
for the complainant.
I am the opposite party.
You've got your money or you haven't got?
Not
What's the check amount?
8 lakh, 80 lakhs. 80 lakhs.
8 lakhs. What is your case?
My lord, in annexure for the in Evidence Act 45, Evidence Act does not considered by the trial court, my lord.
That to raise it in the trial court, sir. Unless you people settle your case, there's no question of quashing this. Permitting the petitioner to urge all the pleas available to the petitioner in accordance with law before the trial court at the appropriate stage. The petition is disposed of. The interim order is vacated. Right.
Item number 67.
Same, my lord.
Same.
Item number 68.
None appears dismissed.
Item number 69.
None appears dismissed.
Item number 70.
None appears dismissed.
Item 71.
This is case, my lord. So 130 enact, my lord. And I have challenged the order of cognizance, my lord. Fact of the case that the petition at the time of relevant time, the petitioner is not a director. That director has been seized. Lordship can see the annexure 3, my lord. That annexure 3, page 19, my lord.
You resigned.
I have resigned, my lord. So he has not in the plain, my lord. He has not stated that he is the sole responsible, or he has not signed the check, my lord. But as per the apex court decision, I have cited 2 or 3 decisions, my lord. I have no role. Prior to that, I have resigned, my lord. The lordship also issue notice, but no till that nobody has appeared, my lord. I am citing same decision of the honorable apex court, my lord. 2005, 10 and 14.
SMS pharmaceutical.
My lord.
SMS pharmaceuticals.
My lord, my lord. SS Pepsi inspector and same thing. Lordship.
Despite service of notice, none appears for opposite party number 2. Paragraph. The petitioner contends that the petitioner ceased to be a director of the accused company by the time the check in question, or out of which the criminal case, the dishonor of which ICC case number 111 of 2015 was registered, the petitioner ceased to be a director of the company. The screenshot of the website of the registrar of companies has been placed on record in support of the such plea. Paragraph. Despite notice, there is no opposition to the present petition. Full stop. Consequently, as far as the petition is concerned, ICC case number 111 of 2015. Are there other accused, or you're the only one?
Other accused, my lord. I am one of the accused. I am the
present petitioner will stand pending in the court of the JMC Barbill. Will stand quashed as far as the present petitioner alone is concerned. In other words, the said criminal case will continue as far as the other accused are concerned. Unless, no, just other accused are concerned. A copy of this order be sent to the concerned court forthwith. Interim order is vacated.
70 to 70. Item 74.
My lord, the annexure 2 is the impugned order. My lord, petitioner before the lordship is an accused in a 138 proceeding, my lord. Order dated 2/11/2017 was challenged before the lordship, my lord. Before taking cognizance, my lord, the evidence of affidavit was filed, my lord. The 41-45 comes after the taking cognizance, my lord. Only recourse available to the accused, my lord, to cross-examine, my lord. So before taking cognizance, my lord, the complainant filed 145 one for NI Act to give his evidence, my lord. The learned magistrate taken into relying a decision, my lord, That was, my lord, before initial, that evidence, my lord, initial affidavits to file, my lord. The London Master taken cognizance. Is a post cognizance 140 petition to affidavit to file, my lord. The pre-cognizance state 145, 142.
All these are technical, sir. What is the check amount?
5 lakhs, my lord.
Ah.
No pleader notice, my lord. No pleader notice, no affidavit has been filed before the court below, my lord.
Why, if you pay that 5 lakhs, then there will be no need for any case at all.
That was a post-dated check, my lord. He has manipulated the date, my lord.
You are for the complainant.
I am for the complainant, my lord.
Ah, he says you used a forged check. You agree that you used a forged check?
Lordship, may take up this matter next Friday, because I have filed a counter, it has not formed in the record.
All right. Counsel appearing for the complainant states that he's filed a counter affidavit, which is not on record. Let's move for the roster bench on 25th April.
Okay.
Item number 75.
Lordships. Pursuant to the affair and of grievance, amicably matter was settled. Unfortunately, my lord, the affidavit still remained in my file.
I see. Mr.
And
Rai
it was-
states that the affidavit as
And
evidence of the matter having been settled will be filed within 3 days.
This there, my lords.
You have to give him a copy, sir. Then you have to.
And the informant has also died.
Petitioner.
Which matter, sir? I hope you're in the right matter.
Yes, yes. I am in the 75,
76.
76. Oh, I'll read.
Petition already died.
Petitioner already died.
Died.
Then there's nothing.
That.
Counsel for the petitioner states the petitioner is expired. In that view of the matter, both petitions are dismissed as having abated. All right.
By 76.
Yeah, 76.
Item 77.
Memo taken on record. No instructions dismissed.
Item number 78.
My lord, item 78 is a matrimonial dispute. I am challenging the order of maintenance, my lord, in the revisional court. In the meantime, my lord, all the amount, my lord, and interim amount, my lord, there is no unpaid amount. All the amount, my lord, deducted from the salary. No, my lord, I pray, my lord, I have no instruction whether they have united or not in the meantime. I pray at least 1 week time so that I could not contact, my lord. Today morning, I tried my level best, but could not contact.
At the request of counsel, the petitioner list for the roster bench on 26th April.
Item 79.
In the end, my lord, permitted to raise all contentions.
Yeah, permitting to raise all contentions. All right.
Item number 80.
Your lordship, may please, your lordship. My lord, this is a purely civil matter, my lord. The case of the complainant is that the petitioners encroached into his suit land, his land. They created a new boundary. 1 meter they have encroached inside the his land, and they have stole 160 number of laterite stones, whose value is 5,400 rupees, my lord. This is purely civil in nature. Your lordship kindly looks at annexure 2, which
Who's
is the
for the
civil suit.
complainant?
My lord, I am for the opposite party. May trial may proceed and it will be decided.
Permitting the petitioner to raise all pleas at the appropriate stage in the trial court. The petition is disposed of. The interim order is vacated.
Item number 81.
None appears dismissed.
Item 81 and 82. Liberty may be granted to raise all the points.
Permitting the petitioner to resolve this.
Item number 83.
My lord, petitioner challenging the order taking cognizance dated 3/9/2017, as well as the entire proceeding in GR case number 1022 of 2016.
Permitting you to raise all pleas at the appropriate stages. Permitting the petitioner to raise all pleas at the appropriate stage in the trial court. The petition is disposed of. Interim order is vacated. Copy the order be communicated forth with the concerned court.
Item number 84.
Yeah, please, your lordship. Here, your lordship, I am seeking for passing of annexure 1. That is the miscase filed by the opposite party number 1 under section 12 of DVAC, your lordship. Here, I am neither their family member nor relative. At one point of time, I was the student of the college where the husband of the present opposite party was in faculty. And in his
miscare is stated that is page 10 yellow tip, paragraph 6, that the petitioners started inquiring about opposite partner number 1 and somehow came to know that the opposite partner number 1 has illicit relationship with opposite partner number 7, who is also a student. In the meantime, I have got married. I am living with the happy conjugal life. Neither I am relative of the husband of opposite partner number 1. No, I have any family relation with them.
What is the case against you? Under what offense?
That is kindly have a glance, page 10, your lordship. Paragraph 6. That is the allegation against me, raised by the present opposite party with the petitioner in the DV miscase, your lordship.
But unless you bring a affidavit to the other party, this can't be quashed at this stage. This must be a highly contested trial.
Your lordship, I have married elsewhere. I am living a happy conjugal life.
Where is an affidavit, sir? Some document has to be placed in record for that.
No, one point of time, I was the student of the institute, where the husband of the present opposite party was a faculty in that institute.
Permitting the petitioner to raise all pleas at the appropriate stage. The trial court, the petition is disposed of. All right.
Item 85.
My lord, as for instruction, my lord, petitioner doesn't want to pursue the matter.
All right. Dismisses, withdraw. All right.
Item number 86.
No instruction. No instructions dismissed.
Item number 87.
87, may I please, your lordship? Your lordship, we will file the discharge petition while the framing of
All right.
charges.
Permitting the petitioner to raise all pleas. All right.
Much obliged, your lordship.
Item number 88.
It is my pardon, my lord, I am on BC. My lord,
Yes.
passing of the criminal proceeding, my lord. My lord, there was a matrimonial dispute and the present petitioner is a village gentleman supposed to settle the dispute and misunderstanding between the husband and wife. And the petitioner is no way connected in the matrimonial dispute, my lord. My lord, in order to settle the misunderstanding and dispute between them, a meeting was convened in their church and the present petitioner used to sit those meetings to settle the dispute, my lord.
So permit you to raise all pleas. All right. Permitting the petitioner to raise all pleas at the appropriate stage in the trial court, the petition is disposed of. The interim order is vacated.
Item number 89.
None appears dismissed.
Item 90.
Item 90, may I plead your lordship?
This matter, if your lordship kindly come to the order dated 3rd of February. Lordship directed the state council specifically to obtain instruction regarding examination of material witnesses and number of witnesses. So I had written a letter. Next Friday only, I will try my best to get it.
So how many adjournments, sir? Man is in jail.
Yes, more than 2 years. So one adjournment only, I will get it from the PP, because the IAC is not responding. I will get it from the public prosecutor, not I assure lordship.
What are your instructions?
Yes, Lord. Here, your lordship, out of 36 witnesses, 12 witnesses have been examined, your lordship. 12, your lordship. Your lordship. All the material witness has already been examined. I have been implicated under section 201/34 IPC, your lordship. The main accused, I am the friend of the main accused, your lordship. Main accused murdered the deceased. By the time he murdered, your lordship, he instructed me to remain in the downstairs, your lordship. I was not aware of that. All the plan hatched by the main accused, your lordship.
All that will have to be examined in the trial, sir.
Yes, your lordship. Lordship, bear me from a moment, your lordship. I have made a short notes along with the date chart, your lordship. Already in custody for more than 2 years and 3 months, your lordship.
302 case, sir.
And your lordship, the maximum sentence will be 7 years, your lordship.
Why 302?
I am implicated under 201, your lordship.
Only?
Yes, your lordship.
So the charge
Are you
sheet-
sure he's charged only under 201? The charge against you is only 201?
Yes, your lord. The allegation against
Where is the order framing charge
that,
against you?
That I have not obtained, your
Ah,
lordship.
You should bring that, sir.
Then let it come.
Counsel, the petitioner insists that as far as the petitioner is concerned, he has been charged only under section 201 read with 34 IPC and for no other offense. Full stop. The order framing charge be released before the court on the next date. List on 17th. 24th?
Yes, your lord.
24th.
17th.
24th February. Over.
For orders item number 1.
302 case, my lord.
How many years in jail?
13 years.
13
Very sensible modern laws. And there is
13 years, sir.
sensible modern clinching materials are there.
You know the Supreme Court judgment also.
That your last can get it from paragraph 23. Of course, laws they are in first.
On that ground only it was rejected earlier. But now again 8 years have passed.
13 years.
14 we had rejected.
The doctor has been murdered in such
You see,
No eyewitness, my lord. Only no eyewitness. Circumstantial evidence.
no circumstantial evidence.
Circumstantial
All right.
27 only.
No, not 27.
Yes.
Even chemical exam report is very clear that unless he has been connected with the crime. Your also can get it from paragraph 23.
So 13 years. Please. You see, earlier, the petitioner's bail application, the applicant's bail application has been rejected in 2014. What's the date, sir? Sorry. On 29th February 2016. That was interim bail.
2 months.
Acha, bail also, correct. Full stop. This being an appeal of 2012, it was expected that the appeal would be heard at an early date. Full stop. However, till date, the final hearing of the appeal has not been possible. And the appellant appears to have spent already 13 years in jail. Full stop. Counsel, the appellant points out that this is a case of circumstantial evidence. Full stop. Following the ruling of the Supreme Court of India in Singada Singh, and keeping in view all the above circumstances, the court directs that the petitioner appellant be enlarged in bail, subject to the satisfaction of the trial court. Paragraph. The paper books, if not already readied, still not readied, is it?
No, still not ready.
Should be prepared and supplied to counsel for the parties within 6 weeks from today, and the appeal be included immediately thereafter in the regular hearing matters. The application is disposed of.
Obliged.
Sir, Pranam.
For orders item number 1.
May I please, Lordship?
Yes, please.
Lordship, by the order dated 23rd February 2021, your Lordship directed to the Indian Oil Corporation to deposit the rent before the DRT Cuttack, Lordship. Now, Lordship, on 21st December 2022, ISL shifted to his own building, Lordship. No more, this premises is no more required, Lordship.
All right.
So, Lordship directed not to deposit the modified to the extent not to deposit the rent amount. And further, Lordship, another things, the original owner who was originally, I am entered into agreement with the original owner. Here is a party, Lordship, and they have made a letter to me that hand over key to me. But in the meantime, auction was made by the bank. So it is difficult to hand over the key to the original owner now. Lordship direct to, I will hand over the key to bank, Lordship. Because bank now is the Miller's.
Who is your landlord?
Miller's, here is a landlord is Miller's deposit. Landlord Miller's RK Panda. RK Panda Miller. I have annexer 3 Miller, annexer C/2. Your Lordship see that. Ramakanda Panda Millers.
Radhakanta.
Yes.
Radhakanta.
Yes.
Radhakanta
Panda.
Ah. Whom are you appearing?
Your Lordship, I am for the auction purchaser. Yeah.
Okay.
Your Lordship.
What is your name?
Your Lordship, my name is Vikrant Patnaik on behalf of Vishwanath Sarangi, Your Lordship. Your Lordship, right now, Your Lordship, the amount of the rent has been deposited in the DRT. So requesting if it can be.
Why don't you hand the key in the DRT? Let the DRT decide.
DRT or the bank?
Your Lordship direct.
Let the DRT, you just deposit with the DRT.
Lordship.
And not to deposit further, Lordship.
Yes. This is an application by the Indian Oil Corporation Limited, bracket IOCL, seeking modification of the order dated 23rd February 2021, passed by this court in writ petition civil 15934 of 2020, in which inter alia it was directed. The directions were issued regarding deposit of rent by IOCL in respect of the premises and its occupation. Full stop. In the present application, it is stated that IOCL has since moved to its own building.
Yes, on 31st/12/2022.
On 31st/12/2022, and therefore should be relieved of the obligation of paying rent in respect to the property in question, which was taken by it on rent. Paragraph. IOCL further seeks directions regarding the keys to the premises and to whom it should be handed over. Full stop. Paragraph. Counsel appearing for the auction purchaser has no objection to IOCL being relieved of the obligation to deposit rents. Full stop. It appears that the matter is still pending in the DRT or DR80.
DR80.
Before the DR80 Cuttack. DR80 is in Calcutta. Right. Full stop. In that view of the matter, the following directions are issued in modification of the directions issued by this court on 23rd February 2021, :1. IOCL need not hereafter deposit any further rent as directed earlier. 2. IOCL will hand over the keys to the premises, will deposit the keys to the premises with the DR80 Kolkata.
DRT Cuttack. We are
okay with the DRT. With the DRT Cuttack, not later than 15th February or 20th February. 20th February 2023. 3. The DRT Cuttack will pass appropriate orders regarding whom the key should be handed over. Right. The application is disposed of.
Item number 2.
May I please, Your Lordship? My lord, this is a review petition against the order dated 3/3/2021 The petitioner approached the Supreme Court and in Supreme Court, the appeal was dismissed at threshold. Again, the petitioner approaches this High Court. My lord, the main
What is the explanation of the delay, sir? 400 days delay.
My lord, the COVID guidelines were there, like that is why the petitioner. The petitioner due to the COVID guidelines, that petitioner not able to file the.
No. The Supreme Court dismissed your petition in limine on 30th September. That is SLP.
Yes, my lords.
How can you file a review after that?
My lords,
Where is the Supreme Court order?
My lord, in the Annex 1, page 34. My lord, the order was dismissed as threshold. And in the light of coded distilleries, my lords, I'm filing this review petition.
No, threshold, what do you mean by threshold? It is dismissed on merit.
Yes.
No, not on merits. My lord, the Supreme Court said they don't see any reasons to interfere in the High Court's order. And that is what my lord, at page 34.
See, in your own case, when a SLP is dismissed, that's the end of the matter. How can you file a review? It's not somebody else's.
The same petitioner.
You can't file a
same judgment.
My lord,
delay was condoned before the Honorable Supreme
Court. Correct.
And thereafter, the Honorable Supreme Court held that there is we are not inclined.
Correct.
My lord, in coded distilleries, my lord, the Supreme Court laid that the Lord laid down in order in Kunha Ahmad, that is not followed. It will not make any difference whether review petition was filed before the filing of special lead petition or filed after dismissal of special lead petition. The situation is covered in para 37, my lord. I'll
anyway, so Supreme Court dismissed the SLP on 30th September.
Yes, my lord.
2022.
Yes, my lord.
When did you file this review petition?
My lord, in December.
So again, what is the delay? 3 months delay again?
My lord,
so there's no COVID and all then? After 30th September 22, there's no COVID.
My lord, my point is like the delay won't defeat the justice, my lord.
What is the ground for review?
My lord, there was an apparent error. My lord, I want to cite Rule 27, subclause 4, subclause 4, subclause 3. My lord, there it says, proof of payment. My lord, I want to establish what proof of payment means. My lord, in the judgment dated 3/3/2021, my lord, the High Court. My lord, and the High Court says, the court is unable to agree with the above submission along with the original application form. It was mandatory for the petitioner to have submitted the original DD and not a color xerox thereof. My lord, nowhere in the rules it is mentioned to submit a original DD, my lords.
Come on, please. The rules don't have to say that, sir.
Rule will say that. How can it be?
My lord,
have you ever heard of saying original DD and photocopy of DD? What is this? I never heard of something like this.
My lord, the original DD is not specified in that auction notice.
Sir, does it have to be? When they say tender a DD, demand draft,
my lords,
you can produce a photocopy.
My lords, we are not given any chance to
what chance? Where's the best of chance? If to submit a demand draft along with an application, obviously has to be the original.
My lord, again.
Anyway, is this the ground for review?
My lords, my lords, in another tender notice, I can show that it was specifically specified that original demand that is needed.
Sir, there's no need to specify. Where's the need to specify?
My lord, this is my ground.
All right. You say, apart from the fact that the court is not satisfied that there is sufficient explanation for the delay in filing the review petition, even accounting for the period during which the petitioner's SLP was pending in the Supreme Court of India, even on merits, the court finds no ground made out to review the order dated 3rd March 2021. Review petition dismissed. Right.
Item number 3.
In item number 3, sub item 1,
But fortunately or unfortunately, the parole is extended.
Still
again.
extended. Why unfortunately? You must be very relaxed and enjoying.
No, that's- I'm not in a position to even work or do anything. Or carry on my business.
Correct.
That is
All right.
sole impediment. Why?
No impediment. You just tell them, sir, I'm very bored of parole. I want to get back to jail. They'll be very happy. The applicant's parole is still continuing. When is now? What date have they given?
15th of March, my lord.
May I humbly pray, my lord? May I humbly pray, my lord? Can a point be formulated whether the ground, this ground of release on furlough, that can be ground for consideration of application under section 389 CRPC, my lord?
Whatever I say, he's still on furlough. So list on 24th March.
Well, 17th is a Friday.
I think it would be
It will,
appropriate.
at this rate at which it is going, I don't see it. 24th March.
17th, so that it can be that's in any event. 17th.
24th March.
Lords, may I be pardoned? I'm on VC.
Yes, yes.
To satisfy the learned government council, my lords, let the point be formulated and be decided.
All right. All right.
Sub-item number 4, criminal offense number 649 of 2019. Which I am appearing, but in one context or other matters, I am now in custody. So there in forum, and within some allegations have been made against me, and I am in custody now. So may I pray, it can be segregated so that it can be taken up.
Let's see next time. Next time, 24th March. All right.
Obliged.
Right. Over. That's what I thought.
Sir, namaskar.
Namaskar, sir. Namaskar.
For orders item number 1.
Last time your lordship directed Lord and AG to take instruction regarding annexure 4.
Lordship may see the order, that order is directing that Utkal, enter order PL Lordship may see that the Utkal University to comply the order. Lordship may see that order, my lord, 12 October 2012.
Yeah, 12/10 to 2012.
The direction was to the Utkal University. And for Utkal University, one Sunil Mathis is appearing.
That's my name may be deleted. Earlier, I was appearing on behalf of the
All right. Court is now informed that Mr. Sunil Matthews was earlier appearing for Utkal University.
He is appearing, my lord, now.
He is still appearing.
His
And,
father is
and the direction was to the Utkal University. In that view of the matter, the registry will inform Mr. Sunil Matthews to remain present on the next date of hearing. The name of Mr. Dayananda Mahapatra be deleted from the cause list.
In the meantime, government also take cognizance in this matter. So lordship kind of
Utkal University to implement that order because they have
the implementation part concern is the government also take cognizance to comply the honorable court order.
So anyway, so it all helps you only, sir. List on 17th March.
Yes, my lord.
Earlier he is retired since 2015, my lord. No pensionary benefit was given.
Or at 10th March. 10th March.
All right.
Item number 2.
Item number 2, my lord. IA number 250, I don't want to press the matter.
All right. This post office is not pressed. All right.
Item number 3.
May I please, your lordship?
Yes.
Thank you. Previously, for the fault of our, the read petition has been dropped.
What's the read petition about?
About the road agreement.
Easement right. So
So we are paying for the restoration of the prayer.
come in the civil suit.
Therefore,
That's what.
Efficacious relief is available.
Correct. For the reason stated, this CMAPL that order dated 6/9/2022 is recalled and WP Civil 3663 of 2022 is restored to file. Then in the writ petition, you say, having heard under counsel of the parties for the petitioner, the court permits the petitioner to agitate the grievance in appropriate proceedings in the civil court in accordance with law and declines to grant the relief in a writ petition as prayed for. The petition is disposed of in the above terms. Right.